16, 17 top national law schools. These all children, bright children, they will go to corporate entity because of this condition.
Yes, yes.
Yes, your lordship.
That's a problem, my lords. And women, my lords?
Should have been imposed in phased manner.
Yes.
The first year it should have been 1 year, next then 2 years, then 3 years. That is the way when court imposed, court created law is made applicable. That should have been 1 year, practice is next then 2 years,
That's
then
right.
3 years. We have unfortunately thrusted upon directly because of that there is a lot of hue and cry in the all top law schools.
Yes.
The children are not going to wait for 3 years because of that waste their time. They are the children who have completed through written exam. Children are not going to compete through a test which is now more rigorous than the NEET or than the medical, and they have got admission as per their merit. Parents have spent a lot of money. Now they are not in a position to wait. That is the crisis we are facing.
That is one, and women.
How to balance both.
That's women also, my
But
lords.
at the same time, we have in judicial crisis. We all have been.
That is one, and women.
At least sitting
That's
here
women
now,
also.
I have the largest experience in, as a judge, as a chief justice, and
That is one, and women.
then in Supreme Court. I have seen, I have been chairman of the Junior Decision Selection Committee, I have been chairperson of the Superior Judicial Service. Augustine, my brother knows, he has been with me. Selection Committee.
So there's a training course, my lords.
We are also, we want that slight mature persons come in judicial service.
There's
That
a
is
training.
also a predicament.
My lords, have it after the selected. Have it after the selected, my lords. That is process that can be in instruction.
We can have a period of
Have it
2
after
years
Just give
of
me 2
training, your
minutes.
lordships.
I have circulated, my lord, some 3-page suggestions on this. Now your lordships have gone through my, broadly gone through what my lord, the high courts and the NLUs are saying. Would your lordship please have a look at my suggestions on this issue and whether some of them appeal to you? Broadly gone through. I'm just circulating. I circulated. In fact, I circulated them today for a reason. And whether some of them appeal to you. No, so I have to. My lord, my lord, as the amicus, I'm not taking any stand, my lord, for a reason. I have to ask him. But also, I have to, my lord, on a serious note, in fact, I should say the moment I circulated this chart, because, you know, 3-4 days back, even before anyone read it, it was on the social media. So today I am giving this suggestion to your lordships, and only recent 1 hour ago, I've given it on the other side. So that, my lord, it's not that this should be first appear there and then before your lord. Lord, may I just read these suggestions, and if your lordship feel any of them are worthy, your lordship will consider. My lord, suggestion 1 is retention of the rule without modification, and I'm just reading it. The first option is retention of the rule in its current form without modification, based on the institutional experience recorded by several high courts in this regard. 7 out of 12 high courts have submitted affidavits, etc., that your lordships have seen. Now, my lord, para 3, requirement of 3 years practice at the bar mandated 7 out of 12 high courts operates as a condition of eligibility for entry into judicial service, and therefore ought to remain uniform across categories. However, considerations relating to suitability of candidates, such as evaluation benchmarks, i.e., cut-off marks, examination modalities, or other aspects of recruitment process, may permit calibrated accommodations consistent with the objectives of the Rights of Persons with Disabilities Act and gender inclusion. This would also include providing infrastructural amenities in court complexes, particularly for persons with disability. High Court of Jammu Kashmir, your lordships have seen, I'm not reading. Lord, now please come to suggestion 2. Particularly relaxation only for women and persons with disability. It is submitted if relaxation in 3 years practice rule is to be granted to any category of candidates, it should be restricted to women and persons with disabilities. It is submitted that uniformity in eligibility conditions should be retained, as the number of categories who may otherwise claim exemptions and relaxations would be beyond enumeration, while relaxations for age, number of attempts or cut-off marks may be granted. As regards eligibility of 3 years experience at the bar, it is submitted that these 2 categories may be permitted to complete the requirement of 3 years experience at the bar either prior to or subsequent to clearing civil judge examination. However, quantum of 3 years may be in terms of. So I am saying, my lord, your lordships may permit them to take the examination if they examination. However, quantum of 3 years. Very well, my lord. I'll just. So I am saying, my lord. Anyway, I am reading it. Them to take the examination if they
Yes.
Very well, my lord.
Yes, your lordship.
Very well. Anyway, I am reading it.
Yes, there can be 6
Right.
training only for practice.
Yes, your lordship.
My lord, may I read paragraph? It is submitted that in case such relaxation is granted to women and persons with disabilities, they be allowed to. So this your lordship saying is not very practical. To sit for civil judge junior division examination as a fresh graduate or as candidates having less than 3 years experience. However, after clearing the examination, they will be mandatory civil judge junior division examination as a fresh graduate or as candidates having less than 3 years experience. However, after clearing the examination,
before the meeting officer will do it.
right.
All these officers should be attached as law class with the not to be studying whether
District judge.
District judge,
Correct.
Your Lordship.
Absolutely.
All
Right.
district judges, all high court judges and in Supreme Court.
Yes, Your Lordship.
That is the best way to teach them.
That will
That is
suffice.
a, that is a proposal made also for the Center for Research.
So that
Yes, Your Lordship.
That is the best way to teach them.
That will suffice.
That is a proposal made also for the Center for Research.
so that yes.
That is the best way to teach them.
My lord, that is in fact contained in suggestion 4. But
Your Lordships, before
once, just one second, let's just be finished. My lord, that is in fact contained in suggestion 4. But
Your Lordships, before
once, just one second, let's just be finished. My lord, that is in fact contained in suggestion 4. But
Your Lordships, before
once, just one second, let's just be finished. My lord, that is in fact contained in suggestion 4. But
Your Lordships, before
once, just one second, let's just be finished. My lord, that is in fact contained in suggestion 4. But
Your Lordships, before
once, just one second, let's just be finished. My lord, that is in fact contained in suggestion 4. But
Your Lordships, before
just one second, let's just be finished. My lord, that is in fact contained in suggestion 4. Suggestion 3. All right, very good.
Your Lordships, my junior here, she is an MBA and she comes from
Suggestion
Guwahati,
three.
Your
All right,
Lordships.
very
She
good.
sat for Guwahati examination in 24, Your Lordships. She couldn't take the mains. Now she came here. Now she's rejected. She sat for Guwahati examination in 24, Your Lordships.
My
She
lord, I'm
couldn't
just
take the
placing
mains.
it
Now
towards the
she
lordship
came
ne
here.
earlier.
Now
My lord,
she's
now I'm not
rejected.
so aware.
She
Para
sat for Guwahati
it is submitted that
examination in
state bar
24, Your
councils may be
Lordships.
directed to. My
She
lord, I'm
couldn't
just
take
develop a mechanism for helping such candidates
the
in
mains. Now
obtaining
she came
requisite
here.
experience after
Now
clearing
she's
preliminary
rejected.
exams.
She sat for
Alternatively, for
Guwahati
the submitted
examination
categories,
in
state bar
24, Your
women's
Lordships.
and
She
minority
couldn't take
disabilities practice period requirement may be
the
raising in
mains. Now
obtaining
she
review
came
or any
here.
other period
Now
as
she's
this honorable
rejected.
court finds appropriate that has come in supplementary categories. Suggestion 3, my lord, this is staggered. In the transition period of next, fresh law graduates may be permitted to judge JD examination. Candidates who clear the examination in Judicial Academy after transition period of next 3 years, 3 year experience will be made mandatory. That is to say, for 3 examination. Yes, correct. Transition period of next 3 years, 3 year experience. Right. So, these courses, the State Judicial Academy can obviously specify, or as your lordship said, law clerkship can. Alternatively, practice period of 3 years prior experience can be 0 years, 1 year, and 2 years, respectively for aspirants appearing for the examinations in the next 3 years, respectively. So, this is another aspect of staggering. Both are staggering. Therefore, 3 years practice, thereafter 3 years practice. So, as your lordship, if perhaps means with your lordship approval, I put it all the other suggestions. I had to put a 3 year rule because all the high courts are saying that their experience for the last 50 years is that they want people. So, Lord, we can't disregard that also. Your lordship, please. And 4 is reasonable accommodation, which in any case should follow, Lord. Whatever it will select your lordship, there has to be accommodation for people who are especially able in terms of infrastructure, in terms of accessibility, in any case, in terms of perhaps finding the judicial internships, and those are suggestions. Lord. In fact,
one suggestion, one big suggestion within this class, one compilation. I'll only refer to one thing. Judgment was just 4.2 minutes at page 10, bottom of the page. Post election curator as opposed to license recommended that the practice page 10. 4.2 at the bottom. Recommended that the practice operated as part of the training curriculum with candidates. After that, the same fashion as the training IAS asked us. Practice experience may be structured in the following manner. Selected candidates undergoing may be practical as an apprentice, law clerk, judge in training, whatever your lordship thinks. In fact, the Center for Research and Planning has come out with this report recommending RAs, law clerks, further strengthen administration. Selected candidates undergoing training for civil judge will be attached with this council, government fees, advocate general, standing council. It is recommended 4.2.2 recommended that certain changes law degree at the university level provides aspirants and or experience opportunity examination. The first one, optional structured 6 practice during the 3-year oblique 5-year law. Similar, for example, for the 5 months, as it stands, not specifically. The second Miller is designed for aspirants college level itself to identify trained aspirants by political purpose. I was referring to the MNLU course, post BA LLB honors post adjudication and judging, as it's called, and that's popular approach because own the skills as a judge is owning the skills council. Take far more liberty. The lordships take far less liberty. So to that extent, my lords, and that is the reason as a judge, because what is not possibly because the courses are extremely helpful and we've been encouraging. One, the younger people for exams itself, takes almost a year or two for applying, for preparing. Secondly, more than one attempt. It's not a single like the AOR examination. You get it on the first. Those are 1, 2, 3, whatever the attempt. Because all that period has to be taken into account for purposes of going down the career ladder. Obstacles particularly more vulnerable for women, something that has to be done away with. That too, mid-level. Constitution bench of these judgments ultimately come out when people have last 3 years, having tried, not succeed, or otherwise prepared, not gone it, or possibly not having enough money. Going in for coaching, as your lordship said, correct. They're all going for coaching in every direction. The school level, besides that, so many documents. Now, you are either out or you are not eligible. But finally, just one last word. Just to graduate not being taken into account this entire exercise. And now, the some universe advocate. But what was management? Who are actually involved? I judge all of this. Assess, not assess this. All the stakeholders has to advise the thing. Not be done like this, one level. And if at all, our exam is come in, there's no at whatever time. Don't even know what chances we there, what will happen. Timing annual exam. The lordships happens 3 years, well, your lordship, modalities might be set. Something must be done. Understood. Well, what should be done after selection? When the law universities and lords during after selection, by way of program, that is another matter. One year, as far as this for them, along with the responsible watches, them when they can exam is also not determined. And depending on whether at that point of time they are getting married, they are having children. So therefore, the Bar Act takes away the entire career opportunity. And like your lordship, then they go into different professions. And very intelligent lordships, because there's no certainty entry. So at that entry point, your lordship, then the barrier is that is the all going forward, your lordship. The career progression appear for all the exams. There is no difficulty. At the level itself, when they are put back, and that's time for
all have experienced it. That is the time when we are all our families. Just as another technologically never been that is the issue, but substantive sadly. Because none of the young girls are able once their family always is that all right now want to do something. Right after graduate and are in that state time your lordship pull back. Tell their families that this is not the time for on to the other age. That is the time for that has to be time your career is what is hurting us. And I Dr. Fernand was because lordship always has moved towards it. So whatever allows people to come in, not lordship, charge of the talent. So then come, not as a not as a they also get a couple of there'll be so our that's not us. That should not be they will women becoming one of the largest lordships. Lordships goes down to the as before. Lordships, we had made it last of the kind of barrier. One is the no higher post, one up to the 1 year or 6 practice. So client relies on a person who is an advocate. Third, structure, infrastructure, and the report, your lordships. There was a report by the of planning and more than 5% are still not accessible. So very lordships. Again, another thing, lordships, the judgment that we were quoting March 2025, that there was a judgment titled as Ayush Yati versus the Court of Madhya Pradesh. There are certain paragraphs. But in paragraph 31, what the use, how it also describes round of quality doctrine. Again, reasonable accommodation. The reasonable accommodation. We are not against practice. We are saying, lordships, we are also somebody that we have to run here and there as seeking accommodation. From there, either we 1 year additional issues or the beginning 1 year and through some legally are legal access. And your lordships have compiled it, submitted before your lordships, issued with through an affidavit, which was a research kind of we had conducted after your lordships passed the news and the High Court of January 26. We conducted one law student and another visit the law graduates and highlighting our
that most of the part of the person will now one is taken now has to be modified or has to be or it could or amended law research attachment of the suffice and have or give that law judicial officer has to lordship those are the submissions from our end. Another thing, lordship, last point. Also, number is 4, 5 regarding the Bihar judicial by the lordship. Lordship that March lordship. I suggest all the lordship does that. The lordship does that. Candidate now to decide. Or did your lordship decide? Modulation be there. Does not impact the young generation.
This is the notification. The lordship will have to pass an order minutes take 2 minutes other way. A different. I'm in 3-0. It is. Because the notification is.
Let me arrive at the newspaper. Level. All the high courts will the direct and the date of last date of level. Thank you. The first that will be by and also have a couple of
Done by the. I'm in. Because he's handed over the Bihar notification. Just one small. Mine is 33. I'm in. I. The concern is requiring higher quality. I am LLM is just passing out now, and well, what's this? All to respect. So far as Law Institute, Kotak, and many other high court has already. I approach the High Court. Us make an application for us higher quality.
I am in law. And it's hard, I can know, hard go post, then ultimately I'm on the level playing. I could not in the meantime, not apply. But not considered as practice. That's correct. Also, I'll be in perjury. That's the point. Why should I mislead? First party is concerned, but this party is dialing wrong number. Then you know, at this is, I may be permitted. I have more than my matter is by this honorable court. No high court is. That's quite obvious. Island. Whatever academic matter, we are not the same. Ultimately, participative litigation.
No, just one small. It would be held that is possible. Why? Because your lordship kindly give it a debate. Also, when we are also anyway.
Your lordship take.
That my lords were of the age, I thought that the order life will start at the day I lord the end date, the light of the 1.5, 2.5, we have 1.5 years have been taken the final appointment, my lord. In effect, that there is 1.5 years. Process right over time direction. But I find best that
May I know the purchase party is your lordship? Fine. 01 point.
position that will be our
301 point. Want to draw your lordship. First is NLU. The mic is 10 NLU. Post part. Second, my lord, I need Nakia University. Clear cut. That's my lord, authored by Faizan Muslim. Very erudite kind. Can understand that as well. We have spent that rate. Yes. We are also trying to ability. Let's be very clear. This is very and key issue modality of giving that number. Right now, for giving how to allow to but how system better quality that may clubs quality outside, I think better than I think that there are all aspects also here should as a